Article pleads with Supreme Court to ignore technicality and accept fresh evidence against Tinubu. Welcome to the news and thank you for tuning in to listen. Please subscribe to our channel to get notified when we post hot juicy news updates. Please click on the notification bell. The presidential candidate of the People's Democratic Party, PDP, in the 2023 presidential election, Atiku Abubakar, has again pleaded with the Supreme Court to ignore technicality and grant his application for leave to tender fresh and additional evidence to support his claim that President Bola Tinubu submitted a forged document to the Independent National Electoral Commission (INEC) to contest the February 25th presidential election. Politics Nigeria reports that Atiku in his reply on the point of law to Tinubu's objection to the grant of leave to present the fresh evidence before the Apex Court submitted that issues of merit ought not to be determined or pronounced upon at the interlocutory stage. He argued that the Supreme Court has intervened time and again to do substantial justice in such matters of great constitutional importance as it did in the cases of Amechi versus INEC 2008, 5 NWLR, Part 1080, 227 Anobi versus INEC 2007, 11 NWLR, Part 1046, 565. Atiku also argued that the presentation of a forged certificate by a candidate for the highest office in the land is a very grave constitutional issue that must not be encouraged. He said that if the Supreme Court grants his application, there will be no need for any further argument other than the written address in support of the same, showing that Tinubu is in violation of the provision of Section 137(1)(j) of the Constitution by presenting a certificate reclamation by the institution from where he purportedly procured same. Atiku said the need to rebuff, eschew and reject technicality and the duty of court to ensure substantial justice is very germane in this matter, given the gravity of a constitutional issue revolved in deciding whether a candidate for the highest office in the land, the office of the president of the country, presented a forged certificate or not. In urging the Honorable Court to overrule the objections of a respondent, we can do no better than to commend to your noble lordships the insightful words of the Supreme Court in Asa and ORS v. Kara and ORS 2014 LPELR 24212 SE Paris Vivo JSC as follows. Law is blind, it has no eyes, it cannot see. That explains why a statue of a woman with the eyes covered can be found in front of some high court. On the contrary, justice is not blind, it has many eyes, it sees and sees very well. The aim, of course, is to do substantial justice between the parties, and any technicality that rears its ugly head to defeat the cause of justice will be rebuffed by the court. In a 20-paragraph affidavit exposed in support of the application, Atiku urged that if the Apex Court grants the application, there will be no need for any further argument other than the written address in support of the same, showing that the second respondent is in violation of the provisions of Section 137(1)(g) of the Constitution by presenting a certificate disclaimed by the institution from where he purportedly procured same. That's contrary to paragraph 16 exile of the second respondent's counter affidavit. There was no ex parte communication with the Honorable Court, but the letter was forwarded to the Registrar of the Court, just as was done in the case of Uzodinma vs. Izunaso 2011 17 NWLR, Part 127530, and at 56, paragraph H of the affidavit on page 56, in which counsel for the second respondent and counsel for the applicant were both involved. The deponent, Mr. Uyigiwa Osagi, further argued that Tinubu's objection was baseless because he was represented both at the discovery and the disposition well as at the court hearing by his Chicago attorneys, and that the and that the second respondent never challenged the issue of venue of the discovery and disposition. That the presence of the first and third respondents at the discovery and deposition was not necessary. That I know that the second respondent's appeal was to prevent the discovery and disposition, and that the appeal failed. The said appeal failed. That I know as a fact that the discovery and disposition were ordered by the district judge and was not out of court. That the appellants were not indolent in their pursuit of the discoveries and disposition, as it was also the later tendered as Exhibit XS2 by second respondent, and the cause of his defense purportedly issued by Caleb Westerberg, that purportedly issued by Caleb Westerberg, that clearly gave the appellant or applicant further reasons to build on the evidence of PW27 by the discovery proceedings for the documents and disposition on oath of the same Caleb Westerberg. That the process for the discovery and disposition was commenced by the applicant with several initial preliminary process by the U.S. attorneys, culminating in their eventually filing a petition for the issuance of subpoena, a copy of which is annexed herewith as Exhibit K. That the process was severely stalled by the vehement opposition of a second respondent, citing irreparable damage to him, among other issues, and I annex here with Exhibit L the motion of a second respondent to squash the subpoena, which application failed. That the process was also further delayed by a motion to join or intervene filed by the second respondent, which was granted, a copy of which application is annexed here with Exhibit M. That eventually the subpoena was ordered and annexed here with a copy of the subpoena along with the documents that accompanied it as Exhibit N. That the second respondent has been in primary possession of all the facts sought in discovery, but took every step to block the release, notwithstanding the second respondent had equally applied through his attorney in the United States, Mr. Wole Afolabi, for the release of a said document, which was released to him as shown is Exhibit